Hi, everyone, and welcome. We're just going to give it a few minutes while everybody starts to filter in before we get started. Okay, while everyone continues to filter in, I'm going to start with some quick housekeeping. Hi, everyone. On behalf of INCLO and the CCLA, welcome to the FRT Principles launch. Para los personas que hablan español, tenemos traducción disponible. Pueden cambiar el idioma en el menú. This session is being recorded. Your cameras are off and will remain off for the entire time. You will have the opportunity to ask questions at the end. I encourage you to put your questions in the Q&A section, and we will try to get to as many as possible. So we have people attending from all over the world. However, as we are hosting this event from Canada, I would like to do a land acknowledgement. So we recognize that many of us are joining from different places in Canada today, and we will not be able to acknowledge all the Indigenous lands our participants are living on. That being said, I would like to acknowledge that CCLA's office is in Toronto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. In the spirit of reconciliation, we acknowledge the land that Indigenous peoples have lived on and taken care of since time immemorial. So with that, I would like to pass it over to my colleague, Timilehin Ojo, for further introductions. Timilehin, take it away.
Thank you very much, Michael, for that great introduction and for setting the tone for today's conversation. I would also say thank you to all attendees for joining us from all around the globe for this historic and remarkable event, Eyes on the Watchers, Challenging the Rise of Police Facial Recognition, is a project by the International Network for Civil Liberties Organizations, INCLO, that examines the use of facial recognition technology, FRT, by the police. It calls for a thorough reevaluation of FRT's use in law enforcement. My task today is pretty exciting, and that is to guide this conversation through and highlight the incredible efforts by the surveillance and digital rights team of INCLO in shaping the principles to be launched today. The purpose of this webinar is to formally unveil the FRT principles document and provide an overview of its key components and how they align with the overarching goals of addressing the human rights arms of FRT in policing. To achieve this objective, our panelists will take us on a journey. First, to understand how the project was birthed, as well as the process that was involved in getting us to the point where we are today. We'll also understand why we need these principles, as well as have a glimpse of the websites dedicated to this project. After which, we shall go further into what the principles provide for specifically, then definitely taking questions from you, our wonderful esteemed audience. As you already know, I am not doing this alone, and joining me in this interesting conversation are some of the most brilliant and vocal voices on the subject. Permits me to introduce Olga Cronin. Olga is a senior policy officer of Enforce at the Irish Council for Civil Liberties in Dublin, ICCL. Olga leads ICCL's campaign against Irish government's proposal to enable the Irish police use of facial recognition technology, FRT. Olga is also the immediate past program manager for the surveillance and digital rights at INCLO. Olga, you're welcome and thank you for joining us. Permit me also to introduce up next, Kemal Daniel Harvey. Kemal is an attorney working at the Cape Town office of the LRC, Legal Resources Center. He has a Bachelor of Social Sciences degree with honors and a Bachelor of Laws degree, both from the University of Cape Town. He is now in his third year at the LRC and works across all of the organization's major programs: land, education, equality, and of course, democratize big tech. He's a passionate social activist lawyer who wants to see the progressive realization of human rights, both in the real world and online. To date, he has researched and presented on new and developing surveillance technologies, including facial recognition technology, and in particular, the potentially negative impacts it may have on human rights. Thank you, Kimal, for joining us, and you're welcome. Finally, I would introduce Daniel Konikov. Daniel is an assistant professor at the University of Alberta's Department of Sociology. He completed his PhD at the University of Toronto's Center for Criminology and Social Legal Studies in 2024. His research focuses on the intersection of justice and technology, and he has recently completed a project on the governance of police use of facial recognition technology in Canada. He was also the director of the Privacy, Technology, and Surveillance Program at the Canadian Civil Liberties Association, CCLA, where he led advocacy efforts around Canada's new legislation on artificial intelligence and cybersecurity. Thank you very much, Daniel, for joining us. You would agree with me that this is a perfect juncture to call upon Olga to kickstart today's conversation. So we'll dive straight into today's subject. Olga, this project didn't just begin today. As it is usually said, Rome wasn't built in a day. Can you take us through the journey of the whys and hows, why efforts in policing, and how did we get to where we are today? I'm talking about the launch.
Thank you. Thanks a million, Timmy. And I might just call upon our technologist, Victor, who's there somewhere to put up our slides. Thank you. Thanks a million, Timmy. That was a great introduction. Welcome to everyone who's come to join us for this. So this is, we're here today to launch Eyes on the Watchers, Challenging the Rise of Police Facial Recognition. Victor, you might just go to the next slide, please. Thanks. So basically, I might just briefly explain what INCLO is. INCLO is the International Network of Civil Liberties Organizations. Our membership spans the global north and south, encompassing all continents. We are made up of 15 independent national civil liberties and human rights organizations worldwide. Essentially, we believe that there's power, wisdom, and opportunity in sharing, collaborating across jurisdictional contexts, and INCLO essentially provides the space and framework for members to come together and work on issues that cut across borders. So as you can see there, we're a network of 15 independent human rights organizations in all of these countries, from Argentina all the way to Australia. And in the next slide, I might just briefly outline, the areas of work that INCLO works on. So INCLO's 4 main pillars of work are civic space, surveillance and digital rights, equality and equity, beg your pardon, and climate and environmental justice. And we also have a growing strategic litigation pillar that cuts across all those 4 pillars, making interventions at various courts, including the European Court of Human Rights, the Inter-American Court of Human Rights, and various other courts across our jurisdictions. So if it's not obvious, INCLO's work on facial recognition technology naturally comes under INCLO's surveillance pillar. And in the next slide, I might indicate what is FRT. First of all, or outline what facial recognition technology is, because there's no point to have a conversation with it if we don't understand what it is. But basically, facial recognition is a type of biometric technology that uses artificial intelligence to identify people through their facial features. And generally speaking, FRT works by comparing a face print or a biometric template of a person's face, possibly taken from an image that could be sourced from CCTV, social media, or body-worn cameras, and comparing that template of a person unknown against a database of stored face prints or biometric templates of people whose identity is known. So the single image is of someone whose identity is not known, and the database of images contain images of people whose identity is known. And these systems are built on the processing of people's unique biometric facial data. So we're talking about the unique measurements of our face. And this kind of data can allow or confirm the unique identification of a person. So if you think about how your DNA is unique to you, or how your fingerprints are unique to you, or how your iris structure in your eyes is unique to you, your face is also unique to you. And that is why it's considered a biometric technology. And in a very broad sense, it's this comparison of images of people unknown against images of people who are known. And the unknown images would be generally called probe images, and the database of known images would generally be called a reference database. And if you're wondering what kind of reference bases of stored biometric facial templates that are used by police, you can think of passport databases or driver's license databases or police mugshot databases. And there's just 3 points I'd like to make here as well about facial recognition. So what I described there is very much the retrospective, the use of facial recognition technology. So we often hear about the difference between live facial recognition technology and retrospective facial recognition technology. I'd also like just to make a point about threshold values and the fact that FRT is a probabilistic technology. So in the first instance, live versus real time. So real time or live facial recognition involves comparing a live camera video feed of faces against a predetermined watch list to find a possible match that then would generate an alert for police to act upon. And these kinds of systems involve the capturing of people's biometric facial data, all those people who would appear in a camera, and feeding it against this watch list. And it would all occur instantaneously or pretty instantaneously. Retrospective involves the comparing of still images or faces of unknown people taken from CCTV or, like I said, maybe social media or body cam footage, and comparing that against this reference database of people who are known. So they're slightly different in terms of timing and how much time a search might take, and in the immediacy of what action could be taken by a police officer after a so-called match comes about. But they're basically the difference. One is after the fact, one is in real time. And so for FRT systems to work, and this is particularly relevant retrospective, there's a threshold value fixed to determine when the software will indicate that a probable match has occurred. And so should this be fixed too low or too high, it can create a high false positive rate or a high false negative rate. So that's when people are misidentified and wrongly, identified as someone that they're not, or someone who they are looking for gets through the cracks or is not highlighted. And just to be clear, there is no single threshold setting which eliminates all errors. And this is what we mean when we talk about facial recognition being a probabilistic technology. And when we think about what a police officer might have in their hand or on their computer after running a FRT search, they essentially would get a list of names, a list of people with their picture, and next to a similarity score. So you'll have person A with an X% probability, person B with a Y% probability. And in the next slide, I'll just show how this probability issue, this probabilistic technology, how it all kind of plays out. So this is an image of what is called an investigative lead report from the Michigan State Police in respect of a man called Robert Williams, a father of 2 from Detroit, who was wrongfully arrested and detained after he was misidentified as a shoplifter by FRT in January 2020. And we could do a whole webinar on Robert's case and everything that went wrong and the terrible injustice that happened to him. But really, I'm trying to draw your attention to this document here so you can visualize how these systems work. So the image on the left is the probe image. So this is the image that was taken from CCTV after a man was seen stealing a watch from a Shinola store in Detroit. And the image on the right is Robert's driver's license photograph. Actually, I think it was an expired driver's license photograph, but it was his driver's license photograph nonetheless. And this was a database that was accessible to the Michigan State Police who ran this FRT search. And so, as it says in the slide there were several FRT searches run on that probe image. And the first showed that Robert was the 9th most likely match for the probe photo. And while 2 other algorithms were run, one in which returned 243 results, but Robert was not on that list. And then on the other search on an FBI database, it returned no candidates at all. So I suppose the point I'm trying to make here is to highlight the arbitrariness of this. You know, there is no guarantee that the person whose identity being sought will be in the reference database. And even if the person is on the top of the list, perhaps they won't, perhaps they should not be, or perhaps if anyone is in the list, they should not be, as Robert was the case. And if a search is returned like this example where there's 243 candidates and the true match was in there somewhere, you know, that would mean that 242 people had been unfairly recommended by an algorithm as having committed a crime they did not commit. And also, it's not guaranteed that the person running the search will choose the correct candidate if they are indeed returned in the candidate list at all. And if you're wondering what happened to the 8 candidates that scored, let's say, above Robert, we don't know. And we at ICCL, we had the pleasure of having Robert in Dublin last summer. And at that point, he still did not know what had happened with the 8 candidates that scored above him. So I just want to make that kind of clear, because I think sometimes it's not very clear that this idea that there's a match and that it's 100%, that's just not how it works. So in the next slide, to just kind of hammer home this point, Robert's not the only person who's been affected and basically wrongfully accused by an algorithm. That's the headline there. All of these people have been brought into the attention of police, arrested, some detained for longer than others, because of them, they were misidentified by FRT for something that they did not do. The cases of Robert, Michael Oliver, Nigeria Parks, Randall Reed, Alonzo Sawyer, beg your pardon, and Portia Woodruff, they're all cases in the US. The case of Sean Thompson and the case of Sarah are cases from the UK in London. Both of these people were, Sean Thompson was walking down a street in London, and he was stopped by the Met Police and being accused of someone whom he wasn't. And he had to show his ID. I think it was his passport before they let him go. I think he was stopped for about 30 minutes. The case of Sarah there, that's not her real name. She was in a store in the UK, and a chain of stores uses live facial recognition technology. So they have a watch list of whom they say are shoplifters, and they run it against the live feed of video when shoppers come in. And in this instance, she was accused of being someone that she was not, and she was ejected from the store. So this is just to show you that this is the downstream effects of this technology. I should say that Big Brother Watch are taking legal action on behalf or with Sean and Sarah. So that would be one to watch. And they've also actually have been other cases of misidentification in Argentina, in Brazil, and other cases in the US. It's also worth mentioning, like, that use of live facial recognition technology in the retail setting. It's not just in the UK, in the US. In December 2023, the Federal Trade Commission ordered Rite Aid to stop using facial recognition technology. Rite Aid is a kind of a giant kind of pharmacy giant or pharmacy chain in the US. And because they were using facial recognition technology, the Federal Trade Commission found that its use was creating thousands of false positive matches, and it was disproportionately affecting people of colour. So these are just a snapshot of cases, because we don't know how many people might take a plea deal, and we don't know. We also don't know how many people who are just not told that facial recognition was used in the case against them, so they don't have an opportunity to perhaps fight it or use it challenge it in their defense. So I might just move on to the next slide there. I'm kind of laboring the point about inaccuracy, which is a dangerous one, and I'll explain that in a second. But I also just want to show this case because it's just so crazy. So this is from research by the great Claire Garvey at Georgetown University Law Center called Garbage In, Garbage Out. And she did amazing research, her and her team there, about the use of facial recognition technology by the New York Police Department. And essentially, because this technology, is not the silver bullet, the magic bullet that it's being put forward. What they found is that some police officers, if let's say, a chin was obscured by a shadow or something was obscured by a hat or glasses, some of the police officers would go on Google Images and, take open mouth or a closed mouth or a set of eyes or open eyes, and then transpose that onto an image, a probe image that they were trying to use for an FRT search, and then do the search, which is bad enough. But then in this instance, this is an example of where they had a probe image of someone, which is that image there that you can see on the left, and they ran that search. There was no results, but they thought because the person looked like Woody Harrelson, they took a picture of Woody Harrelson and they ran that picture. So this is just to kind of hammer home that point about how unreliable it can be. But on the next slide, I kind of want to move away from the issue, or sorry, I suppose I should say, with facial recognition technology, there's basically twin dangers. There's the risk of misidentifications because it's reliable. And there's FRT error rates can come about because of multiple factors, like the quality of the image, is the lighting, the pose of the person, if they're looking at the camera, if they're not, if the camera is coming down from above, all of these, and the threshold for similarity, which can be changed by the law enforcement authority that's using it. But apart from all of those issues, there are scientific studies that show and have clearly demonstrated deeply inherent racial and gender biases within facial recognition technology, which is why you saw on the slide earlier that the people who are misidentified primarily are Black. And we often hear of, figures being put forward to support the use of facial recognition technology because they might say, oh, it's 99% accurate. But when you actually dig down into it, first of all, they may be talking about a type of facial recognition technology that is not comparable to the one that they want in their jurisdiction. Or even if you deep digger down into those figures, you will still see this this discriminatory effect and these biased results against people who are not white and male. But focusing on the accuracy issues with FRT, while important because they are immediate harms, isn't always helpful for us in kind of civil society who are trying to raise the issues here, because there are long-term consequences with facial recognition technology. And I've just made the point there, or the in quotes there, press rewind on. So this is this idea that we can just press rewind in someone's life. It's a seismic shift in powers of the police that that we are reduced to walking license plates, in the words of the European Data Protection Board. And it does that power to identify us wherever we go is huge, and it's unprecedented. And we've seen how it's been abused, this kind of technology, in terms of how the IDF have treated Palestinians, the treatment of Uyghur Muslims, and the treatment of protesters in Russia. So if just to go to the next slide, thanks, Victor. So just on those long-term consequences, the technology is always improving. We know that. We know these companies out there are there to make money. But as much as there are issues with the accuracy issues around technology, we don't want it to be perfect and correct 100% of the time, because for such a perfect system, that would require all our images to be in a database in the first place. It would require systems to be trained on all types of facial poses and configurations. And ultimately, that would be bedding down infrastructure for mass surveillance outright. So however discriminatory and defective it is, and we have to call that out, we have to make it clear that we're not calling for it to be, we don't want it to be perfect either, because it just creates too much of it's such a powerful, dangerous tool. And I have just again repeating links there as to how this has been used against certain people across the world. So it's these long-term consequences that we have to be extremely conscious of and vigilant about. So it's not just about focusing on the accuracy issues. And especially as political systems change and political priorities change, we just need to be continually mindful of what authorities might use such a powerful tool for. So this idea that, so for the next slide, I just want to briefly touch on the kind of rights, the human rights that would be affected by policing facial recognition technology. So there are more, but we just wanted to include a rundown of kind of the ones that are most pressing. So the right to dignity, this idea that we would just be turned into a walking barcode, you know, or treated as a commodity. The right to privacy, the right to be able to go somewhere without someone knowing that you're there, the right to freedom of expression, and to protest, the right to equality and non-discrimination, the rights of people with disabilities. In 2023, the UN Special Rapporteur on Disability recommended a moratorium on FRT and emotion recognition technology because of how they discriminate against people with a disability. He made the point that there was evidence that some applications resulted in some people with disabilities being judged untrustworthy because their face did not conform to the standard program in the artificial intelligence system. And then, you know, as in the examples I've shown earlier, you know, the right to presumption of innocence, the right to effective remedy, the right to fair trial and due process, all of these human rights, all of these rights are affected by policing facial recognition technology. So I'll just go, if we go to the next slide and just briefly touch on the work that INCLO has previously done on police use of facial recognition technology. So in 2020, we and INCLO and Privacy International, we held a side event at the UN Human Rights Council on facial recognition technology during protest. During the years of COVID, the use of FRT by authorities to seek to monitor quarantine compliance, especially in Russia and Hungary, was something that we had worked on. In early 2021, we produced a report called In Focus, which was basically a compilation of stories showing how the use of FRT impacts the rights and the everyday lives of citizens across 13 countries. And in 2023, we revisited the topic by having a webinar and report where we kind of revisited the subject with our friends at CCLA in Toronto. And we had our expert speakers speaking up to the experiences from Argentina, Canada, Israel, the US, and the UK. And actually, it was at that gathering that we decided that we should consider creating a set of principles for FRT. If I go to the next slide, and the reason that we decided to do that was because we could see that there was many examples and egregious examples of FRT in our relevant jurisdictions, and our members were working on these topics and on these cases and situations. So just to run through them quickly, our colleagues at ACRI were doing their best to try to find out exactly what was happening with this buildup of a biometric database of Palestinians by the IDF. They filed a petition to try and find out information about it. It was basically a number of ex-soldiers from a group called Breaking the Silence came out and talked about how an app was being used to tell a soldier if a person was able to leave, if they were to be questioned, if they were to be arrested. So sorry, basically there was a collection of images of Palestinians from child up to elderly, and then there was this database, and then they started to use this app called Blue Wolf. Our colleagues in Russia, in Agora, were taking a case to the European Court of Human Rights over the use of FRT to identify a politician and a protester who were at a protest. Our colleagues in Argentina were working with people who were wrongfully arrested because of facial recognition technology. The case of Robert Williams, our colleagues at ACLU, there was the Bridges versus South Wales police case in the UK, our colleagues in Liberty, the Clearview AI scandal in Canada, which Daniel might talk about briefly, or in a bit. And then we also had the case in Buenos Aires in 2022 when the use of facial recognition technology was suspended in the city of Buenos Aires. So that was a situation where this was a tool presented in, I think, 2019, and it was supposed to only catch the fugitives. And there was something like 30 or 40,000 names or people in this database, but it turned out the government had actually done searches on 7 million people. Then there was the case at the European Court of Human Rights, the Timilehin versus Russia, and there was the state of New Jersey case, Francisco Artiga. So that Timilehin, excuse me if I'm correct, or pronouncing that incorrectly, apologies, but that was a case about the European Court of Human Rights in regards to the Russian authorities using FRT to identify and apprehend a protester. And the state of New Jersey versus Francisco Arteaga, that was a case which was about disclosure in terms of the defendant could not get access to the details around the FRT system that was used against him. So that was a really significant case in terms of what information they ruled the authorities had to give him. So anyway, basically, we looked at all these situations and we could see that different members were in different situations. Some of our members were calling for outright bans. Some of our members were calling for a moratorium, and some of our members were calling for regulation. They were calling for laws and guardrails. And this is because of this patchwork situation that everyone found themselves in. Like some people, there was no legal basis, and then FRT was being used, or in others, a legal basis was being used, but it was inadequate. And so it was for this reason, this patchwork situation, that we decided it was time to grapple with the issues and create a set of principles that our members could best use for their situation. So in the next slide, I'll just mention kind of our methodology. So essentially, we had a small steering group managing the project with our members, feeding into the process step by step. We held meetings throughout the year and followed up by email, obviously, and all of that. But what we did is we started off by carrying out country surveys and asking our members to basically explain to us what the legal approach is in their country, what's happening in their country, what kind of level of public debate and consultation is happening. Are there any assessments or audits or evaluations there, and any other information? So like, we really kind of want to know what's the legal basis there, tell us how the police are using it, and if there are oversight mechanisms, are they, effective, transparency, all of these questions. And so kind of after we got all of those surveys, we decided to kind of agree on harms and risks of facial recognition technology. So we agreed upon a text of that. And then after looking at those harms and risks, we agreed upon a set of questions, and we tried to look at, the kind of the spectrum of FRT from when a police officer buys it, essentially, and then to when it's used and what happens then in court afterwards. So we have tried to cover that whole kind of spectrum. And so after we looked further at those risks and harms and considered each step, we agreed on a pretty lengthy set of questions that we felt should be answered if we're, to try and hold authorities to account. And we've included a lot of these kind of questions in our report. And we hope that they're useful for others to use when they want to ask questions, but they may not be sure as to what to ask. So not only are we launching these principles, but we're trying to outline to people what kind of questions they should be asking. And not just civil society, members of the public, journalists, to really understand. So if we can understand the risks and harms, then we can ask the right questions. That's kind of where we were coming from. And so we then finalized our principles, and we did have an expert feedback session with a number of amazing people who work in academia and civil society, who were very generous with their time. And we also had, that was a virtual meeting. And then we also took another opportunity late last year, to meet with some of those experts in person, but also other academics as well. And then everyone's probably sick of hearing my voice, but we'll just go to one last slide, and just to say, so these are the principles. Now, this is this is a very kind of shorthand for the principles, but there's 18 principles, and I'll get back into them or go into them in some detail after this. But basically, yeah, we have these 18 principles, and like I said, we hope that they encompass the spectrum of deploying an FRT system, from the establishment of a legal foundation to the practical implementation of it. So I'll stop there, but they are the principles, but we can get into them in a bit. Thanks,
Thank you
Timi.
very much, Olga. Thank you so much for that very brief summary of the issues and what's actually led us to the point where we are today of launching the principles. It was a very good highlight of the dangers, what we should be looking out for, misinformation, mass surveillance, and the exact cases where this issue is a big question already in reality. So it's not a fictitious kind of subject. It's something that is live, and it's something that is really a concern as hands-on. We'll return back to you in a bit, and we'll get to hear more on the principles. But before then, this is a good point to turn the conversation to Kemal. And Kemal, with that important background that Olga has just shared, and the dangers and consequences pointed out, which led to the making of the principles. It's going to be great to hear your thoughts on why we need these principles from the South African context. And this is especially useful considering the November 2024 report of the LRC, which revealed an increased usage and expansion of FRT in South Africa.
Thanks, Timilehin, and thank you for that presentation, Olga. It was very good. And from the South African perspective, as you've asked, the one thing that I wanted to highlight from Olga's presentation is one of the last slides that spoke about how FRT in particular can be a tool of apartheid. And I think that's really important with the South African context, is because just because activists and social democracy and the constitution has dismantled the South African apartheid as we know it, from a legal perspective, the socioeconomic political situation for many people, particularly Black South Africans, hasn't changed at all. And I think it's really important when we talk about FRT and surveillance in general to understand, the sociological context of South Africa. And so why is FRT or surveillance technology being placed in South Africa? Why has it suddenly become such an interesting thing for both private parties, but also state parties? And there's two reasons. The first is probably the less important reason for a lot of these users of the technology, and that's an identification, registration, and certification of populations reason. But I think most people are introducing surveillance technology or are interested in surveillance technology because of crime prevention. And when we talk about crime prevention, we're primarily speaking about groups and communities in South Africa that are the minority. They live in big houses with tall walls, electric fences, and soon to come now is CCTV with FRT technology. But that's just, the private context as well. Obviously, as a government, the South African state has a role to play in crime prevention. And one of the things that they've done is they've worked with our Department of Home Affairs, who are responsible for the sort of population registration, certification, and identification, to create a system that's known as the Automated Biometric Information System. Now that, like I said, it's integrating the system so that we can have a list of everyone that's in the country, and that comes from our IDs, our driver's licenses, our passports and stuff. But what's really important to this discussion is that this system also seeks to introduce an FRT, system where people's photographs that they're taken so that they can have some form of identification is now going to be integrated into a system that can be used by police officers to identify people in crime prevention efforts. Now, I think what's one of the really important principles that was mentioned, and it's also in international law, is that these photographs that this sort of automated facial recognition technology has created are of sufficient quality so that we can be as accurate as possible. My biggest worry, and I think a lot of social activists' worry in the South African context, is that we're going to start to see a lot of cases like the Robert Williams case here in South Africa, because you then bring in, sort of AI technology into FRT, and then we're going to see a lot of technology that's not set up for identifying, Black individuals, and then we're going to get a lot of misidentification issues. Another important thing to bring out, and I think it's spoken throughout all the principles, is that you need a proper legislative and regulatory background for how the FRT system is set up in any country, not just in South Africa. And the biggest problem at the moment in South Africa is we do not have one. A couple of years ago, or many years ago, we had an act that, you know, regulated surveillance. The problem is that that act, it's called the RICA Act. It allowed for bulk surveillance. You know, another one of the big issues that Olga identified about FRT. So this act was struck down by the Constitutional Court because it allowed a bulk surveillance, primarily through cell phones and listening into conversations and SMSs and such stuff like that. But it would have, in our day now with FRT, it would have translated in some way. Luckily, that's been struck down, but the issue is it's left this hole, this legal lacuna, as we call it in legal speak. And what that means is that states and private individuals can act with impunity. So just to, you know, round it all off, I mean, we really need these principles, and we really need our legislators and politicians to look at them and properly consider them.
Thank you very much, Kimal. Thanks for bringing it home down to South Africa and helping us to understand exactly the situation and just as you mentioned, the lack of legislation. I'll take you on back on that question very soon, but let's take it back to Canada. Daniel, having listened to the state of things in South Africa, you've also heard the principles, the reason why we have the principles itself from Olga, and taking in mind the privacy's guideline on facial recognition of police agencies by the privacy commissioners and the Office of the Privacy Commissioner of Canada. How, in your opinion, does the Canadian framework intersect or interact with the INCLO principles?
Yeah, that's a great question. I think in order to cover that, we need to kind of provide some background on something that Olga already teed up super well, which is the Clearview AI controversy. The Clearview AI controversy was essentially this watershed moment for facial recognition in Canada. And it sort of revealed, among other things, something that Kamal has already mentioned, which is maybe a lack of policy, regulation, guidelines, legal framework, this legal lacuna, as he said, regarding facial recognition. For a quick primer, Clearview AI is a company that produces a facial recognition tool that is licensed primarily to police, law enforcement. It was revealed in late 2019, early 2020, that a number of law enforcement agencies around the world, but most notably in North America, had been using this tool without without notifying the public. And the reason that this tool was particularly concerning was because it was built on a database of some billions of images that had been scraped from the internet without people's awareness, without people's consent. So once the proverbial stuff hit the fan with Clearview AI, it led to perhaps a lot of soul searching among police in Canada, but also some movements on other regulatory fronts as well. And what emerged were a few different approaches to governing, or at least trying to govern, FRT, to put that proverbial genie back in the bottle. The biggest, or some of the biggest, most seismic maybe source of that push towards there being some sort of regulation was, as you mentioned, Timilehin, the Office of the Privacy Commissioner of Canada's guidance that they had developed in tandem with our provincial and territorial privacy commissioners as well, regarding police use of facial recognition. And this is a very privacy-centric document that identifies what to, just sort of crib the language directly from the OPC's work, to sort of highlight the patchwork, right? There is no specific legal framework for facial recognition use in Canada, as this document explains, and rather this legal framework is built up of a bunch of patchwork statutes and a bunch of common law, whether those be federal or provincial privacy laws, or statutes regulating police powers and activities. but it really pointed to this big gap. And so the guidance from some of the research that I did was seen to have, I'd say, a sort of like split impact, right? It seemed to either inspire some police departments to go on their own and develop their own in-house modes of regulation. So the Toronto Police Service, for example, they had started this process beforehand, but these sort of overlap to develop this their own policies and regarding artificial intelligence, right? Facial rec would fall within that category, but took a broader sort of position. But it also inspired a bunch of law enforcement agencies to sort of back off and wait and see until there was some sort of firmer legislative ground that they could stand on. I don't want to take up too much time here, but I think what we've then sort of seen since that guidance emerged is a bit of movement, but not a ton, right? Ideally, more movement would be ideal. If police are planning on using facial rec, which it seems very much like they are, then that should be done in conversation with privacy commissioners and others, but should also sort of engage writ large with, lawmakers should engage writ large with what that OPC guideline pushes for, which, to tie this into the principles, is really what kicks off our principles document in the first place, which is that there should be some sort of specific legal basis, right? So I'd say the cleanest alignment between the principles and what the OPC guidelines say is that while this might be a stopgap, or while this might provide some sort of basis for thinking through these complicated issues, it's not a substitute, right, for there actually being major legislative change.
Thank you so much, Daniel. I hear you say clearly the fact that so much more work needs to still be done. And we'll be coming back to you to give some pointers on what should be done next, what should be the immediate next step, especially with the principles already being available at this time. But let's take it back to Olga. Olga, with all the backgrounds of it, we definitely on this call would be on a consensus to agree that there's a need of the principles. So what exactly are contained in these principles? Can you take us through that quickly?
Thanks, Timmy. And I might just ask, thanks, Victor. Victor's our technologist, who's also one of the main people who drafted the principles, just to say that. So principle one, so sorry, just to say these slides are just very, very, just a headline for the principle. And I'd encourage folks to go on the website, inclo.net/FRT to see them in full. But I will just go through them. So the first principle is, and it's just to back up that point, both from Kamal and from Daniel, that there's, at the very least, there has to be a legal basis. And so basically, any interference with a right, and FRT interferes with many rights, must have a legal basis, and that legal basis must be sufficient quality to protect against arbitrary interferences. We say here that, police must not use or collect, store, or disclose personal information related to any FRT use, unless such actions would be authorized by a specific law. And we would also say that the law must specify the strict circumstances under which FRT use can be authorized and be written in a manner that ensures all citizens and residents can understand and foresee the exact conditions and circumstances in which FRT is being deployed or will be deployed. The second principle in the next slide is about fundamental rights impact assessments being mandatory. So here we're saying that the police need to carry out a series of impact assessments with respect to all fundamental rights prior to any use case of FRT. And we're saying that these assessments must include an assessment of the strict necessity and proportionality of the FRT use. We go into some detail, but there's 18 principles, so I don't want to take up too much time, but we do say that for the fundamental rights impact assessments, they must explicitly outline the specific parameters of its use, who will use it, who will it be used against, where will it be used, why will it be used, and how it will be used. They have to include, a an assessment of the rights impacted, in particular the rights to privacy, protection of personal data, freedom of expression, the right to protest, and non-discrimination. It must include an assessment of the nature and extent to the risks of those rights, of the risks to those rights, and how each of those risks will be mitigated. A demonstrated justification for how and why the benefits of the deployment will outweigh the rights impacts, and the remedy available to someone who is either misidentified or whose biometric data is processed when it should not have been. And just for the sake of clarity here, when we say misidentified, for the purpose of these principles, we're talking about the wrong selection of a person from that candidate list that I mentioned earlier, by a human reviewer of the FRT system, or search rather, which would precede a law enforcement action or an action by the police based on that selection. And we also make it very clear that in respect of the necessity and proportionality assessment, that assessment must detail the necessity of the deployment for a stated and legitimate objective, and include evidence to the problem being addressed by the FRT deployment, an evidence-based explanation as to how the FRT deployment would be genuinely effective in addressing the problem, and a demonstration of why existing and less intrusive measures, which do not include FRT, would not be sufficient and meet the legitimate objective. So, like I said, the principles are a lot more detailed than they look in the slide, so I just encourage people to have a look later. In the next slide, our principle 3 is about these fundamental rights impact assessments having to be independent of vendor assessments. So what we're saying here is that those assessment obligations I mentioned earlier, in terms of fundamental rights and necessity and proportionality, they have to be carried out, irrespective of any possible potential legal obligations on FRT vendors to publish data about their algorithms and source data. I think it's fair to say that this principle was largely inspired in many ways by an argument won by Ed Bridges and our member organisation in the UK, Liberty, in the Bridges versus South Wales police case. So in this case, the Court of Appeal held that a public sector equality duty under the Equality Act there requires public authorities to give regard to whether a policy could have a discriminatory impact. And in this case, the court held that the South Wales police had not taken reasonable steps to make inquiries as to whether or not the FRT that the police were using risked bias on racial or sex grounds. So given we know the issues with the tech, we know this is hugely important. Even as I stressed earlier, that the problems with the tech do not diminish as the tech gets better. But essentially, according to this judgment, it was said the police were not aware. Sorry, just to go back during the court proceedings, the police said they didn't know the data set that was used to train the FRT system that they were using, and they argued, it was difficult for them to confirm whether or not the technology was inherently biased as a result of its training data. And the court heard from a witness who was employed by a company specializing in FRT, who said that these kinds of details are commercially sensitive and cannot be released. And this is something that we hear a lot, that this data is commercially sensitive and can't be shared. But the court held that while this was understandable, it wasn't good enough, and that the police never sought to satisfy themselves either way of or by way of independent verification that the software didn't have an unacceptable bias or ground on the grounds of race or sex. So that was largely where that was inspired from. In principle 4, we say that there should be no acquisition or deployment of any new facial recognition technology without a guarantee of future independence from a vendor. So what this is about is what's called vendor lock-in risk, which is a risk that a customer, which in this case would be the police force using FRT, that they would be at risk of not being able to transition or move to another vendor. So the risk is essentially that they would be locked into continuing with the vendor. And the issue here could be that the customer, i.e. the police, could be stuck with a very bad system or a very bad vendor. And this is probably one of the more technical principles. So again, I'd invite folks to have a look at that in more detail there. For the next slide, principle 5, we're saying that all the versions of assessments would have to be made public before the facial recognition technology deployment. So this is quite obvious, you know, but we're essentially saying that all versions of assessments, including the strict necessity and proportionality assessments and human rights impact assessments and their results, would have to be made public prior to the deployment in a manner that maximizes public reach, especially among the people who are most likely to be subject to a specific FRT use. Principle 6 then, in the next slide, is about an obligation of public consultation. This is also quite detailed, but basically what we're saying here is that before any policing body deploys FRT, it must hold meaningful public consultations, including with members of communities who will be disproportionately affected by FRT use. We do go into some detail as to what that consultation must involve, but I just wanted to flag that we do include the stipulation that it should include a mechanism and guarantee to ensure the consultation process can actually influence, shape, and even possibly cancel the deployment. So that's principle 6. Principle 7 then is about, we say the authorities must inform the public how probe images are used in an FRT operation. So if you remember from earlier, I explained the probe image is the image of the unknown person taken from CCTV or wherever, and they want to run that. So if you remember the example of Robert Williams, the probe image was that very dark, blurry image of a man in a shop. And what we're saying here is that police must make public the details of how probe images are used in an FRT operation, the criteria necessary for a person's image to become a probe image, the sources of probe images, the length of time they're held until they might be destroyed, and the legal basis for obtaining, retaining, and processing those images. The principle 8 then goes into the technical specifications of any FRT system. And what we're saying here is that these technical specifications must be made public before deployment. So like it says in the tin, what we're saying is before any deployment of FRT by law enforcement authority, the authority must make public details of the technical specifications of any FRT system it plans to use in a clear and intelligible manner. And this is a bit like the vendor lock-in principle. It's also pretty technical, but we're saying that these details should include description of all hardware and software components, a breakdown of the system into its various subsystems and modules, a visual representation of the system design and architecture, the error rates for the FRT system, including false positive and false negative, as well as documentation on how the error rates were calculated. Principle 9 then is, so this is banned uses. So here we're saying that live FRT is prohibited. This principle is very straightforward. We just say live FRT is just too dangerous and it should be banned. That does not mean that retrospective FRT is not dangerous. It is, and in fact, you know, live FRT, you know, it happens instantaneously. There's a danger of no friction between when an alert is sent to a police officer and when action could be taken. But tracking someone over time, over months at a protest is equally dangerous. So I just want to make that clear, that we're not saying that retrospective is not as bad as live. It can be equally dangerous. But our principle here is that live FRT should be banned. You know, and elsewhere throughout the principles, we also say that it should be banned. It should not be used at protests or used to identify whistleblowers or journalists or journalistic sources. We say it shouldn't be used to identify people who've no evidentiary link, indirect or direct, with a crime, or to categorize people by a protected characteristics, or for social scoring and other things like that, or to try and infer someone's emotions, all of that. But this specific principle is about a strict ban on the use of live FRT and on the use of FRT in recorded videos, because this is this idea that you can just pull so much data and map someone's life very, very quickly. And we actually have a good example of this where this is already in place. So going back to the Robert Williams case and all the brilliant work our colleagues at ACLU did, it's now the case that the Detroit Police Department, they changed their policy in light of what happened to Robert and others. And so their specific policy around the use of facial recognition technology strictly prohibits the use of FRT on live or recorded video. And whether that material comes from the cops themselves or from private citizens. So just wanted to flag that as well. Principle 10 then, I'm almost there. So principle 10 then is about mandatory prior judicial authorization. And here we're saying that a police officer will not be permitted to use FRT unless there is prior judicial authorization for such use, except in duly maybe justified urgent cases, whereby a higher ranking officer, wholly independent of the investigation, must give approval. But in there, we make it clear that that would be an exceptional case, and that judicial authorization must still be requested without undue delay and no later than 48 hours. Principle 11 is, this is a record of use. So here we're saying that the police must document each and every FRT search performed and provide this documentation to an independent oversight body. That, I haven't mentioned it yet, but that's in Principle 16. Principle 16 provides for an independent oversight body. But what we're saying here is that the police have to document each and every FRT search, and that kind of documentation must include, who made the request, when and why, if the request, the details of the reference database that was used. And we're also looking to kind of get aggregate information on the use of FRT in regards to the total number of searches, the total number of searches that generated leads, the total number of searches that resulted in an arrest or charges, the number of individuals who appeared as a possible match, who were subsequently questioned, arrested, or charged, and also a demographic breakdown of individuals in probe photos by race and gender. So there's a lot of detail in that one, but here we're just, again, this is about transparency and accountability by having this information being shared with this independent oversight body. And we're also saying that every database of images used by a police officer for search, so this is like the reference database, must be audited at least annually to ensure that it does not contain images that are no longer legally permitted or to be retained, or if there's wrong information, etc. And these audits must also go to the oversight body. Principle 12 then is, here we're saying that an FRT result alone is not sufficient basis for questioning or arresting or detaining a person. We're saying that a police officer will not question, arrest, detain, or take any action against an individual on the basis of FRT use alone. It should not result in a person being included in a photographic or physical lineup. FRT is not reliable evidence, and any FRT must be followed. Any FRT result should be followed up by independent, reliable investigative actions before law enforcement can take any action. And really, like, if you remember and if you can recall the image of that investigative lead report from the Michigan State Police of Robert, like, it says in the top of it, I think in red writing, this is just an investigative lead, but like, this is difficult here. But the principle is that police cannot just take an action based on the FRT result alone. Principle 13 then is this obligation to disclose. So this is about mandatory disclosure of details of an FRT operation applied against individuals. So here we're saying that police officers must disclose to anyone detained, questioned, arrested, charged, or prosecuted after an FRT search, without restriction, details of the FRT operation applied to them and the technical specifications of the system involved in the investigation. And I should say here that this was very much shaped by the result in the state of New Jersey versus Francisco Ortega case I mentioned earlier, where there was amazing work done by this Defense Lawyers Association, people like Claire Garvey and ACLU and EFN. And basically, this is a case where just to backtrack a small bit, in the US, an emerging issue is that people aren't being told that FRT was used against them. So, which is, makes them to challenge the charges against them really, really difficult. So, in this case in New Jersey, it was a significant win because the court there ruled that the state had to give the defendant all this detailed information about FRT that was used against them and how it works, the source code, its error rate, all of this. So it was a significant precedent. So this was very much shaped by this. And basically the court held that Mr. Ortega, he would be deprived of his due process rights unless he could access what the police had used to identify him and test its reliability to build a defense. So as I said, it was a significant precedent. Then Principle 14, I'm nearly there, sorry, folks. So this is about FRT misidentification. So here we're saying that any FRT misidentification of a person must be reported to the person by the law enforcement authority as soon as possible after the misidentification is discovered and recorded. And again, as I said, misidentification here for the purpose of these principles is the wrong selection of a person from a candidate list by a human reviewer, which precedes police action, such as being put on a reference database or watch list or questioned, arrested, detained, or prosecuted. Principle 15 then is mandatory annual reporting by authorities of misidentification. So here we're saying that the police authorities that use FRT must produce an annual report outlining anonymized statistics pertaining to misidentification. So these reports would include the nature, source, and impact of the error and any steps taken by the law enforcement authority in response to the misidentifications. And these must be made public and provided to the oversight body. Finally, we're coming to the principle for the oversight body in Principle 16. So this is about, so here we're saying that there has to be an independent oversight body that would be established before any deployment of FRT. And so, and the purpose of this body is to assess the use of FRT and its compliance or otherwise with fundamental rights, but the application of whichever law that they are working under, and also these principles themselves. We're also saying that the body should be provided with expertise and resources to develop an evaluation methodology for that assessment or those assessments. And that this evaluation methodology should include a minimum set of requirements that the FRC system must meet, and below which the system should be decommissioned. And we're also saying that the oversight body should have the power to order the decommissioning when the minimum set of requirements are not met. Principle 17 then, the second last one, is again about the independent oversight body, but we're saying that it must publish annual accounts. So it must publish annual reports which will include all the written assessments mentioned in the principles, but also a detailed assessment of and comment on, the legal basis that they're using, and a list of further details about FRT use that are all there that you can see in that slide. And again, this is all about accountability and transparency. And then the final principle, Principle 18, is about impact assessments being made available to the oversight body before the system is deployed. So here we're saying the details and findings of all those assessments must be made available to the oversight body before the system is deployed to assess and evaluate the police officers' findings when they make their assessments. So that's the principles. I might just briefly show folks the website. That's okay. Folks can see that.
Okay.
I can. Can you see that, Timmy?
Yeah, it's gonna be popped up. Yes. So that's the website.
Oh, okay. You can see the website. Okay. So this is the website. And I have to say a big thanks to Taryn and to Mir and to our wonderful artists for this design. So this is the website. The principles are here. Just kind of very much a summary of them, the 18 that I just kind of took everyone through. We talk about what is FRT, we talk about what it's used for, the steps involved, the types of technology, types of FRT, beg your pardon, and then we come down into the principles. The menu here will show you, will also take you to each of these places. We go into further detail about why FRT is unreliable and discriminatory. We talk about the probe image, the database, the training data set. We also talk about here about the rights and the risks and the harms of FRT. This is Alina Najil's art. I just want to give a shout out to her work there. And so we go into details about these and how these rights are affected. So hopefully people find that useful. And then, sorry, we talk about, impact assessment. So this is these. So as I mentioned very earlier on in the launch, I was talking about how we kind of set upon a bunch of very detailed questions that we think should be asked, and hopefully these will also be useful for folks, in terms of like really getting to understand and to think about the dangers of the technology and what questions have to be asked in order to understand it. And finally, I suppose this is a good note to kind of end on. It's just about how we envision folks using the principles. So, like, essentially, we think that they are useful for many for many people. We hope that they could be used by civil society, by members of the public, to voice their opposition for the deployment of FRT in their respective jurisdictions by understanding the issues and being able to articulate them, and also use them as a kind of an education piece for others to help other people and empower other people to also ask those questions. We also see them being used by folks who may be engaging with police authorities, who may be setting up protocols or codes of practice or whatever around the use of FRT. But mostly, we hope that we hope that people can use them to strengthen their fight against the introduction of FRT. We know that battle has been lost in many jurisdictions, but we hope that they can help people at least call for certain bans and restrictions if that's impossible, but in other jurisdictions, maybe win that fight. And so, yeah, that's how we hope people will use them. And also just, to build cases against the harms produced by FRT, but also just to really ground any kind of advocacy or campaign initiative, just make sure that it's grounded in a very clear understanding of the issues. Thanks to me.
Thank you very much, Olga. That was an amazing rundown of those principles, which definitely are much more elaborate than what has just been shown. Thank you for doing just a perfect job in taking us through those principles. A reminder to everyone who definitely want to take your questions, who wants to hear from you, and our panelists are very happy to attend and respond to every question you may have regarding those principles and how they apply. Just if you have questions, drop them using the Q&A function on the Zoom platform, and we'll take those questions. We definitely want to take as many as we can, so please put your questions in from this time, and we'll be attending to them. One question I would like to throw to Daniel and Kimal. We've read the principles, 18 of them. Now, which of the principles do you think stand out for you, or is most applicable in addressing the issues that you've identified in your various jurisdictions? I'll call Daniel to kickstart that.
Great. Yeah, thank you. Just in the interest of time, I will blitz through a few of these. We've already spoken at length about the first principle and how law enforcement must not use FRT without specific legal basis. I think that is probably the most pressing, at least, and I'm sure Kamal would probably say the same, not to step on any toes, but there are a number of others that are tremendously relevant. The principle about how public consultation should be obligatory. This is something that has that is front of mind in the wake of Clearview, as Clearview AI's facial recognition tool was acquired without, right? And so we've seen a number of police, law enforcement agencies take up this mantle of public consultation and try to ensure that these processes are transparent and democratic. However, there's some inconsistency here. So, for example, a police department in Ontario, the Halton Police Department, has recently started using facial rec by essentially piggybacking on other jurisdictions that have already implemented it, that are nearby, but that also did a more advanced consultation. So Halton Police has done this without consulting the folks of the Halton region, right? I believe the chief of police in Halton said that soon there will be explanations to the public about how facial recognition works, and police will soon make themselves available to answer questions. But as you can likely imagine, the decision has already been made, right? So whether or not these public consultations will be meaningful in any way is up for debate, and is something that these principles hit at, right? The public consultations around facial recognition should be able to delineate what can be influenced, what can and should ideally be able to have some sort of effect, should be able to shape the outcome, right? It seems like in this case, maybe that outcome is already a done deal. And a few, and just one other that I think is worth mentioning would be the emphasis on independent oversight. As law enforcement agencies are taking these issues seriously and starting to govern or try to regulate AI-driven tools within their own departments, they're creating these internal mechanisms to provide that sort of oversight, but those mechanisms are just that. They're very internal and comprised of individuals or experts from within police units, right? Different units, which provides a diverse perspective to be sure, but doesn't provide that outside knowledge or that outside regulatory influence. I'll leave it there in the interest of time.
Thank you so much, Daniel. Kim,
No problem.
I'll move over to you just immediately because I see a couple of questions that I would need to attend to.
Sure, thank you. And good job, Olga. That was a lot of principles to get through. So yeah, I mean, Daniel, I agree with you. We've spoken about the legal basis thing already, so I'm not going to go too much into how there's none in South Africa. But what I do want to link it to is that when a legislative process in South Africa starts, as Daniel mentioned already, this public consultation thing is so important. And I want to kind of also bring in, I think it's principle 2 and 5 about the human rights perspective. I mean, human rights assessment, right? So any public consultation and human rights assessment, they need to kind of happen, concurrently or the same time or absolutely together. When we're talking about FRT or any just sort of surveillance law that has been put out there, it needs to go through the public process. People need to be aware of what this is going to do, what are the risks, and the government or whoever's making the legislation needs to present that to the people. But I won't talk too much about that. What I want to say, though, is that South Africa does have an existing legislation that regulates and legislates for the storing of personal information. And within that act, there's also this idea of personal, metadata, right? And so when we're talking about people's photographs or their identity that coming from our Home Affairs system is now being passed off to the police service, there's a real conversation here about did I consent when I took my photograph for my ID? Did I consent to have myself surveilled by the police? And I think the answer is pretty fundamentally no. And then the last thing I want to talk about is I want to talk about this horizontal surveillance issue that's happening in South Africa, particularly around the crime prevention ideas. Most of the CCTV inbuilt FRT systems that are in South Africa are privately run by private security companies. So, for example, in Gauteng, which is one of the 9 provinces in South Africa, I think there was about 7,000 cameras across the province that were implemented that specifically have FRT technology in it. These are live recording CCTVs. Olga, you spoke about Principle 9, about how that should be, just banned completely. because we have no legislative basis for something like that, or legislative basis or regulation around like private security in and of itself in that sense, we have no idea whether or not the FRT is there doing it retrospectively or if they're doing it right in the moment. And what are they cross-referencing our images with? Is it the same automated biometric information system that's coming out of Home Affairs, or is it based on, old footage of that person walking that street? We don't know. And I think this just, goes back to this publicly available information system that we need to, really get to the bottom of. The LRC are going to do our best to push against this and push for, legislative and regulatory change. But to bring it to what Daniel was saying about an oversight body, we can't rely on the courts every time and long legal proceedings to, make law for us. We need someone there at the forefront dealing with this and with the expertise to deal with it.
Thank you very much, Kimao. That was definitely very, very spot on. And talking about what database is being used to match this information with, we have a question that's speaking to that specifically. And the question says, in your experience, which databases are commonly used by law enforcement to match an image to an identity? Are you aware of any jurisprudence or policy discussion around the lawfulness of access to these databases without proper legal basis? I would leave it open. I don't know if anyone wants to speak to that. Okay, Olga, please shoot.
Thanks, Jimmy. Daniel or Kamal might be aware, but I don't know of any jurisprudence specifically around the use of databases. But commonly they would be, the databases used would be, let's say in the States, their driver's license databases or police mugshot databases. In the UK, it's police mugshot databases, but there was an announcement, I don't know, how was it, maybe a year ago, where there was talk of maybe using the passport database, which, is so problematic because you're essentially, everyone in that database is in a lineup. There's just no two ways about it. Even if the person that they were seeking was in it, all the other people who would come back as a candidate, are being misidentified as someone as possibly having, committed a crime. I do think that that's something that's kind of ripe for potentially like a litigation, a case. And I imagine, and I wouldn't be surprised if it's somewhere in the UK where that would be taken shortly. There's a lot of issues in the UK over the legal basis for the use of FRT. It's very patchwork. It's a mix of different laws. And a lot of kind of academic scholars there say it's kind of, it's ripe for a case. So maybe watch that space maybe, yeah.
Thank you for that point, Olga. So I'll just state this quickly. Would be pleading that I would be going just 10 minutes past the call to attend to all the questions. And if you need to leave, please don't feel obligated to stay back. The recording would be sent to all participants after the call. But would like to take all the questions that we have before calling it a day. Next question is directed to Daniel. And the question is pretty straightforward. Any ideas when Canada is going to implement the FRT?
Yeah, it's already happening. I think that maybe that's a little bit of a broad question, but I think part of what we've been getting at here is that it's already in use by police and it's here. That's kind of the quickest answer I can provide. If they'd like to provide a more specific example of that. There's also, plans of using FRT in broader contexts as well. I believe Air Canada has been unveiling a voluntary use of facial rec for boarding or for security. I believe it's supposed to sort of provide an alternative to showing some sort of identification or passport. So facial recognition has been already normalized and is present in the country.
Thank you so much, Daniel. Olga, I guess we're coming back to you. And the question next is saying, these principles, do they not legitimize the use of this technology? That's what the question is.
Yeah, and you know what, Jimmy, and to that person who asked the question, that is a legitimate question. This is really, really difficult. We are absolutely not legitimizing facial recognition technology used by police. We are absolutely not. The reason we created these principles is because, like I hopefully tried to explain earlier, is that our members are in situations where, like Kamal explained, they don't know if FRT is being used, or they do know what's being used, but they don't know where it's being used or how it's being used. So, you know, while people are fighting back against that, and saying, calling for an outright ban, or some people are calling for a moratorium, or some people are calling for legislation because they've lost the fight to stop it and prevent it, and they can't rewind the clock. And this is the thing with surveillance technologies. Once they're introduced, it's very hard to stop them or to turn them off, which is why in Ireland we're campaigning for this not to be introduced. But we're lucky to be in the position where we can fight against it. But it's just a fact that some of our members are in jurisdictions where that fight has been somewhat lost, and so they're trying to do the next best thing by holding the police to account, by bringing in restrictions or bringing in certain bans or drawing particular bright red lines that they can't go over. But we're not legitimizing it, and we're just responding to the situation that we find ourselves in, and it is really, really difficult.
Thank you so much, Olga, for re-emphasizing that point. And yes, that point is pretty emphasized even in the principles itself, that this is not a blueprint to say use the technology, but it's rather a way to say, okay, if you are in that situation where it's either being used and you don't know, or you just need to respond to the use compulsorily, whether you've accepted it or not, then you can use the principles to fight to ensure that human rights are not being violated. Next question, I'll bring it on to Kemal. And now we have the principles. Again, it's flowing from the last question. The principles are here now. How exactly are the best ways to use them to achieve a result, in your opinion?
These principles are kind of, you know, brought out of existing international, you know, policy and law. And I think whenever we make, you know, suggestions or commentaries on how legislation should look or regulation should look, you can't just do it within, you know, one context. You've got to, you know, look at it abroad and see how things have been regulated or, you know, badly regulated in other spaces, and learn from those mistakes or from the good examples. I think what these principles do very well is they outline exactly how FRT should be regulated, but it also, you know, it also speaks to each of the issues, you know, such as misidentification and mass surveillance, and then helps us, you know, twist that in a way where we can, you know, make sure that the regulation or legislation that you use to regulate the FRT in your country properly. But it also, I think, more importantly, from a, you know, civil society point of view, it gives us the tools, you know, to push against this narrative. So as Daniel mentioned for the Canada question, it is there already. And as I've mentioned, FRT is in South Africa already. Many people didn't know that. I didn't know that until, you know, the beginning of last year. And so now it's important that now that I do know it and I have these tools in front of me, I can use them to push against them, maybe in a litigation point of view, but maybe also just from an advocacy point of view.
Thank you so much for giving that very clear direction on how to make use of the principles. The next question again goes back to Olga, and the question is: are there plans to implement FRT in the Irish police force?
Yes, is the short answer, sadly. So in May 2022, our Justice Minister announced that she wanted to have facial recognition technology up and running for the Irish police by the end of the year. And ICCL has been campaigning against that. It hasn't happened yet, but there was a draft bill brought out last year, which was really problematic, is really problematic. It essentially just allows, or it suggests that the Gardaí, our Irish police, would be able to just use any imagery to carry out an FRT search to move on an investigation. So it's not even a case of them needing to identify someone who's has any kind of evidentiary link to a crime. So we've been campaigning against it. Now we were told, and the bill strictly prohibited live facial recognition technology, but just the new government that has come in recent weeks, the programme for government says that it wants to bring in live facial recognition technology. So that is a big departure from where we were before Christmas or before the election. So, and I suppose the backdrop to the Irish case is we've had the AI Act in Europe, and that essentially allows for member states to pass laws for law enforcement use of facial recognition technology, both retrospective and live. Now, live, it's largely prohibited, but there are exceptions, and there are always exceptions. But having said that, the AI Act also says that member states can bring in more restrictive laws and more restrictive conditions around use than what the AI Act provides for. So that's the situation we're in. They are able, under EU law, to pass a law to bring in FRT. They said that they would not bring in live FRT, they would just bring in retrospective, which is equally, as I'm trying to hammer home, is equally dangerous. And we're now in a situation where they've done a U-turn and said that they're going to bring in both live and retrospective. But ICCL is still campaigning against this introduction. So the short answer is yes, but I hope I tried to explain that.
Yeah, definitely. I believe that's definitely answers the question in full. Now, the next question we have here is, will there be trade secrecy protections for providers of FRT companies that will limit the full ability to understand why conclusions were reached by the tools? Also, should exemptions in trade secrecy protections be considered? I would call on Daniel. Would you want to give this question a shot?
I'll give it I'll give it a shot. But I would love to throw it to Olga or Kamal afterward. Yeah, I think the idea of trade secrecy has been sort of part and parcel of all technologized surveillance, right? And has sort of allowed companies to vendors, as we referred as referred to in the principles, to sort of sidestep any sort of meaningful disclosure, and that is a sort of difficult logjam to break, I'd say, sort of up against a broader philosophy as well as like legal regime regarding information that is sort of kept as proprietary for intellectual property reasons, for example. It would be nice if police, law enforcement agencies, and vendors could establish some sort of baseline for what would be acceptable for transparency. Recognize that this is an uphill battle, but this is exactly what the principles, I think, are uniquely set up to do, which is by providing one end of this sort of transparency approach, which is please disclose as much information as you can. Hopefully, it's able to move the needle in a more positive, disclosure focused, transparent direction. I know that's a little bit of a hem and haw answer, but I would love to throw it to anyone else who might be able to chime in more specifically on trade secrecy.
I'm not sure if I'm fully going to answer the question, but it may be useful to know that, let's say, under the AI Act, at least, so retrospective FRT would be considered high risk. So the AI Act, as you all know, is it's a risk-based kind of regulation. So retrospective FRT is seen as a high risk. Live FRT is seen as prohibited, basically, like it's too risky, except in these exemptions. But there are certain, because it's coming under high risk AI systems, they have to follow certain procedural rules before certain tools are put on the market. So these are kind of providers and deployers of them. So there's risk management systems, there's data and data governance, technical documentation, and there's transparency requirements there as well. So there may be something there, but I'm not entirely sure if I'm completely answering that question. And conformity assessments as well. So there may be some transparency there, but I guess we'll just have to wait and see. And also, these things will have to be in place before a member state will be able to use the technology. But there's a whole other webinar, I think, in the AI Act. So.
I just wanted to add one more thing. I apologize, which is that certain law enforcement agencies that have been mounting their own efforts to govern artificial intelligence tools writ large within their organization. Some of them have been providing AI inventories, they call them, right? So I think that that is perhaps a positive development on this front. It does not provide as much information as one might find satisfying regarding technical specifications, but usually these inventories take the shape of at least rendering or shedding light, right, on the existence of these tools or the presence of these tools within a law enforcement agency's tool belt. And will usually share who the vendor was, what the intended purpose or use of the technology is, who its authorized users are, right? So being a little bit more forthright with who actually within the organization is allowed to, administer or apply these tools, as well as maybe some steps towards mitigating risk, right? There's still a long way to go, and the principles outline some of the ways in which that information can be, these uses can be rendered even more transparent. But I think some of these AI inventories are a compelling start towards a more radical approach to transparency.
That's great. Thank you so much for the input on that particular question, as well as other questions. And now I guess we'll be moving back to Olga. And the question at this point is there any way the principles can be enforced at any point? Olga, you would go first on that, then I would come back to Kima on that same question.
Well, the principles should be enforced if the principle around the independent oversight body is enforced. That is probably the biggest kind of check in there, and obviously the legal basis and everything else. But the idea that you would have this independent oversight body that would be resourced, would have the legal basis and have the powers to do what we're saying it should be able to do, then it should be. So I mean, that would be the short answer there. But I think it's a fair question, because there are obviously there's obviously concerns about whenever you kind of put forward something like this, that things become just a kind of tick box exercise, and there's work has to we have to be really vigilant about that when to prevent that from happening. Like there's a lot of detail that we could do another project just on those assessments and what they have comprised of to really copper fasten what's needed. But because we're a network of 15 organizations across 15 jurisdictions, the principles could only be written to a certain level, at such a high level and such a low level that would make it applicable to everyone. But that would be the answer to the question. Yeah, I think as long as that oversight body, independent, resourced, and given the legal basis and the powers that we say, that should work.
All right, Kima, just quickly, can you also speak to that question?
Yeah, of course. And then if you don't mind, I'm just going to answer the South African related question as well, because I think there's an important link here. So I know I was in the beginning a little bit doom and gloom. There's no legislative basis for FRT in South Africa, and it's how do we enforce these principles without that? Well, I mean, one of the great things, and is one of the reasons that I'm a human rights lawyer, is our Constitution provides a great fundamental protection for it, for human rights in South Africa. And so, as Olga mentioned in her presentation, this system, in the way that it's envisioned by the companies that are implementing it, and the state and the way that they're implementing it, violates fundamental human rights that are enshrined in the South African Bill of Rights, which is the first chapter of the Constitution. And so there's many creative ways in which we can take FRT use that's seen as discriminatory or in violation of those rights to court, and to argue for better regulation. My very strategic litigation answer is strategic litigation, and so we take it there with this wider goal of asking the government, or rather forcing the government, to make regulation and legislation and then bring in oversight bodies within the writing of that legislative process. But I mean, that is a long process, and so hopefully we can push from other realms to get these principles into a piece of law without having to go through the slog of going through the court system. And then I agree. I mean, one part of that system is the public participation process, and I agree it doesn't work. I agree that especially with something like this, where it comes to surveillance, there's a lot of arguments about national security and we need to keep things in trade secrets, that kind of stuff. But when we're talking about something that's, impacting our everyday lives and marginalizing communities, the stuff has to happen in the public realm.
Thank you so much, Kimal. Olga, I guess, okay, just before I come back to Olga, Daniel, is there any other closing statements you'd want to add before we draw the curtain?
No, I think I'm just grateful to have been involved with this panel. I know I'm no longer within the civil society realm as I've moved on to academia, but I'm always happy to speak on these issues that I love teaching about, I'm passionate about researching, and I'm passionate about there being some sort of meaningful change. So hopefully these principles work in tandem with a lot of the hard work that many regulators like the OPC or the IPC in Canada have been pushing for, better, stronger legal frameworks around facial recognition. Thank you for involving me.
Thank you, Daniel. Olga, just one final question for you. We definitely wish we could take more, but we have to call it a day at some point. Now, the question just says simply, will you provide more information on the website regarding FRT complaints and do investigative work into such complaints?
Thank you, Timmy. We would certainly love to. We would love to do that, Christopher. We'll have to see amongst our focal points across the jurisdictions if we can do that. Again, it'll just be capacity, but I definitely think that there is huge value in doing that, for sure.
Thank you so much. And I'll just at this point say we are not able to continue with any more questions. Olga, any final statements, as well as Kimal?
Just to say thanks to everyone who's come here to join us today and who's listened to, especially me drone on and on. And we really, really appreciate it. And again, I'm just kind of conscious of that former person who asked the question, are we just kind of legitimizing it? I just really want to reiterate that we are not, in our view, the risks and potential harms associated with FRT systems outweigh any possible benefits. And, these substantial costs to both our individual privacy, but also societal trust, we say make its deployment unjustifiable. But what we really hope that people take from this project is that they have the tools to ask the right questions, to really grapple with the technology and to understand at every single point along its journey, where the questions have to be asked and where assessments have to be, and it's only by asking those questions that we kind of get answers. It also puts pressure on legislators. We often hear, media interviews with certain people talking about FRT, and it's just unfortunate that there's certain questions that aren't being asked and they aren't kind of being pressed on to answer. So hopefully the project equips people with power to ask those questions and fight back against the proliferation of FRT.
Thank you, Olga. All right, thank you so much to everyone, and we really appreciate the time. I'll pass it on to Michael, who's been very helpful providing all the necessary facilitation to make sure we have a smooth running. Michael, over to you, please.
Perfect. Thank you, everybody, and thank you for participating. Thank you, everybody, for coming. I just want to let everybody know, so this has been recorded. We will be resending the recording out through CCLA. So please look out for that in the next week or so. And also, we hope you come out to one of these events in the future. So at CCLA, we hold them every quarter, and we hope to have ones with INCLO involved as well in the future. So look out for that as well. So with that, I'll end it. So thank you, everybody. Goodbye.
Thank you.